Assalamualaikum warahmatullahi wabarakatuh. We are from group Ekora Reborn. I am Adam Haris bin MUSTAPA. My group mates, KHAIRUL AZIZUL bin Muhammad AZRUL, Ryan UZAER bin NORSHAHZAN, Muhammad AIMAN ATIF bin YAHAYA, and Muhammad AFIQ MUQRI bin Muhammad ZAKI.
Now, let's move on to the issue 1. The issue 1 is whether the Prime Minister's declaration of a nationwide security area under Section 18 of the National Security Council Act 2016 is authorized by the Federal Constitution. In this part, we will have two sub-issues. Now, let's go to the sub-issue 1. The sub-issue 1 is whether the executive usurp the exclusive constitutional prerogative of the YTPA under Article 150 emergencies power by effectively creating a nationwide emergency without royal assent. Now we have two provisions here. The first is the Article 151 of the Federal Constitution, which states that YDPA may proclaim emergency if His Majesty is satisfied that a grave emergency exists. The Section 18 of the National Security Council Act give the power to YDPA to declare security area if His Majesty finds that the security is threatened. For your information, before this, the power of declaring security area is under the Prime Minister. But after the constitutional amendment that was passed in 2020, the amendment transferred the power of declaring security area under the National Security Council Act solely from the Prime Minister to the Yang di-Pertuan Agong. This shows that now the power to declare the security area under the National Security Council Act is under the Yang di-Pertuan Agong, not the Prime Minister. Now, let's move on to the first case. Now, I quoted for the Hong Type J in Stephen Carlo Lincoln versus Government of Malaysia. It states that the Yang di-Pertuan Agong is not an autocratic ruler, since Article 41 of the Federal Constitution provides that in the exercise of his functions under this constitutional or federal law, the Yang di-Pertuan Agong shall act in accordance to the advice of the Cabinet. This shows that YDPA must act according to the advice of the Cabinet under the Article 40, Clause 1 of the Constitution, even though the executive authority is vested to His Majesty under the Article 39 of the Constitution. Now, let's move on to its application. Guru declared the whole country under security area and imposed curfew. This declaration constitutes an emergency because Guru put the entire country under security and imposed curfew. Guru overstepped his authority by using the Section 18 of the National Security Council Act 2016 by declaring the nationwide emergency. Why Guru overstepped or misused his authority? Because the power to declare the security area under the National Security Council Act, as mentioned earlier, is only to the Yang di-Pertuan Agong, not the Prime Minister. So, in conclusion, for the first sub-issue, Guru declaration of the nationwide security area and imposing curfew are void because it is against Article 150, Clause 1 of the Federal Constitution and also the Section 18 of the National Security Council Act, which vested the power only to the Yang di-Pertuan Agong. Now, let's move on to the sub-issue 2. Sub-issue 2 is whether a nationwide declaration of a security area is a colorable exercise of power and a bad faith expansion of the National Security Council Act, which was originally intended for localized threats rather than political self-preservation. For your information, the law never grants an absolute power to a figure. Even if so, the law grants broad power to a figure, as for example, the Prime Minister. The power must be exercised in good faith and it must comply with the objective conferred by the Parliament. A colorable exercise of powers occurs when an executive uses the statutory provision for improper purposes. Now, I quoted back the previous provision, which is Section 18, Clause 1 of the National Security Council Act 2016, give the power to declare the security area only to the Yang di-Pertuan Agong. I quoted from the Raja Azlan Shah in case of Pengarah Tanah dan Galian Wilayah Persekutuan versus Seri Lempat and Terpasang Berhad, where Raja Azlan Shah said every legal power must have legal limits, otherwise there is dictatorship. Discretion means a sound and discretion guided by law. It must be governed by rule, not by humor, and it must not be arbitrary, vague, and fanciful. So, from this judgment of Raja Azlan Shah, it shows that law never grant an absolute power. And even so, the law gives discretion or absolute power to a figure. It must be governed by rule, and it has its own limitation. Otherwise, it is a dictatorship. Now, by applying the provisions and the cases to this part, is that Guru abandoned his anti-corruption. Guru abandoned his anti-corruption stance, embezzled the public fund, and appointed his family members and financial backers to high-ranking government positions. Not only that, Guru also order the immediate takedown of Gaga and Gigi's social media account, and charge them for sedition. Guru misused his authority under Section 80, Clause 1 of the National Security Council Act by putting the whole country under security area and imposing curfew when he is panicking over his waving popularity. All of these facts show that mala fide, bad part, or bad faith on Guru when he is imposing emergency when he is facing political backlash. In conclusion, the nationwide declaration of security area declared by Guru is colorable exercise of power and best faith expansion of the National Security Council Act. Now, that's all for my part. Now, I pass the floor to my colleague.
Now moving on to the second issue, which is whether the nationwide curfew and resultant ban on the planned peaceful rally unconstitutionally infringe upon the rights to freedom of speech and expression and peaceful assembly. This issue is further divided into two sub-issues. The first sub-issue is whether the nationwide curfew, which effectively prohibited the planned peaceful rally and related political expression, violates the right to freedom of speech and expression under Article 10, Clause 1, Paragraph A. Article 10, Clause 1, Paragraph A guarantees citizens freedom of speech, and this includes digital dissemination as held in PP and Fua Keng Tong. We distinguish with the case of Haris Fatilah bin Muhammad and Suruhanjaya Pilihan Raya Malaysia, where in that case, the court held that in Malaysia there is no constitutional right to information. Furthermore, in Article 10, Clause 2, Paragraph A and Article 10, Clause 4 provides that Parliament may restrict speech for among others, public order or sensitive matters. And this is further supported by Mat Suhaimi and Pendakwa Raya. But the most important legal principle is found in the case of Muhammad Ilham bin Idham and Kerajaan Malaysia, where the court dictates that any state restriction must maintain a genuine objective and rational nexus to actual public tranquility. Applying the rules mentioned, the executive orders freezing accounts and enforcing a curfew directly block political expression, which established prima facie breach. Under Haris Fatilah, Gaga and Gigi assert a negative right against state censorship, not a demand for government records. The state's public order defense fails because PM Guru acted out of personal panic over exposed embezzlement, not a national security threat. Cutting digital communication has zero rational connection to public peace, which failed the test in Muhammad Ilham. Furthermore, Article 10, Clause 4 is inapplicable because the post targeted financial corruption, not sensitive constitutional pillars. In conclusion, the nationwide curfew and ban on the planned peaceful rally violate the right to freedom of speech and expression under Article 10, Clause 1, Paragraph A. Therefore, because there is no objective rational nexus, the digital suppression and curfew are unconstitutional and void. The second sub-issue is whether the nationwide curfew, which automatically banned the proposed public rally, violates the right to peaceful assembly under Article 10, Clause 1, Paragraph B. Article 10, Clause 1, Paragraph B and Section 4, Subsection 1 of Peaceful Assembly Act protect the right to assemble peaceably. Section 9, Subsection 1 establishes a non-prohibitive advance notification regime, replacing the old permit system. In PP Ismail and Brownlee's, in the case of PP and Ismail and Brownlee's Law of Public Order, it provides definition of assembly as gathering of persons that is complete by mere collection or aggregation. Most importantly, the case of Amir Hariri bin Abdul Hadi and Public Prosecutor holds that any executive action operating as prior total restraint on peaceful assembly violates proportionality under Article 8 Clause 1 and is void. In the present case, Gigi's proposed demonstration is a protected assembly. By invoking the National Security Council Act to enforce a blanket nationwide curfew, Guru applied an absolute prior restraint. This bypassed the notification of Section 9, Subsection 1 of PAA and dismantled the right to gather before the event occurred. Locking down the nation to preemptively suppress a protest against embezzlement is widely disproportionate under Article 8, Clause 1. Weaponizing security laws as a personal shield cannot be justified under Article 10, Clause 2, Paragraph B. In conclusion, the nationwide curfew and rally ban violate Article 10, Clause 1, Paragraph B as they impose a disproportionate and absolute restraint on peaceful assembly. Therefore, under Amir Hariri standard, the curfew and rally ban are unconstitutional, overreaches with no legal effect.
2 and 2.3, which concern the freezing of social media accounts, the nationwide curfew, and whether these actions violated Gaga's and Gigi's fundamental rights under Articles 13, 10, and 8, Clause 1 of the Federal Constitution. On issue 2.2, the first question is whether the social media accounts are protected property under Article 13. Article 13, Clause 1 provides that no person shall be deprived of property save in accordance with law. And Article 13, Clause 2 prohibits compulsory acquisition without adequate compensation. Now, while Malaysian courts have not directly ruled on whether social media accounts constitute property, applying the purposive approach from Loh Koi Chun and Government of Malaysia, property should be read generously to include assets with real commercial value. Gigi's accounts were not personal profiles, they were also active tools for his Sharia-compliant business enterprises with genuine economic significance. Their indefinite removal without compensation engages Article 13, Clause 2, and the summary manner in which it was done without any court order or lawful procedure violates Article 13, Clause 1 as well. On the freedom of expression limb, Article 10, Clause 1, Paragraph A guarantees every citizen the right to freedom of speech and expression. Yes, Article 10, Clause 2, Paragraph 8 allows Parliament to restrict this right in the interest of public order, but as the Federal Court held in Sibarasa Rahsia and Badan Peguam Malaysia, any such restriction must be proportionate. It must go no further than what is reasonably necessary. Here, the entire accounts were frozen and removed. If specific posts were considered problematic, targeted removal would have been the proportionate response. But a blanket takedown goes far beyond that, and it fails the proportionality test. We also submit that both actions were carried out immediately without any notice or opportunity to be heard, so this violates the rules of natural justice, which are embedded in Malaysia's constitutional framework. Gaga and Gigi were given no chance to contest the orders before they were enforced. On issue 2.3, the issue is whether the curfew and these bans violated Article 8, Clause 1, which provides that all persons are equal before the law and entitled to the equal protection of the law. In Datuk Haji Harun bin Haji Idris and Public Prosecutor, the Federal Court affirmed that while classification under the law is permissible, any such classification must bear a reasonable nexus to the object of legislation. Where the law is applied in pursuit of an improper purpose, Article 8, Clause 1 is violated. Here, the pattern is clear. Guru, who has personally engaged in embezzlement, cronyism, and abuse of power, faces no legal scrutiny at all. Yet Gaga and Gigi, whose only acts were offering private advice and posting in support of honest governance, face account freezings, a nationwide curfew, arrest, and sedition charges. The NSC Act 2016 and the Communications and Multimedia Act 1998 are facially neutral instruments. But when they are deployed exclusively against political critics while shielding the actual wrongdoers, they are no longer being used for their legislative purpose. They are being weaponized for personal political protection, which is precisely the arbitrary discrimination that Article 8, Clause 1 prohibits. For these reasons, we submit that the actions taken against Gaga and Gigi are unconstitutional on all three grounds under Articles 13, 10, and 8, Clause 1 of the Federal Constitution.
For the third issue, the arrest of Gaga and Gigi violated Article 5, Clause 1 of the Federal Constitution, which guarantees that no person shall be deprived of personal liberty except in accordance with law. The phrase "in accordance with law" is not limited to any statute passed by Parliament. In Tan Teck Seng and Suruhanjaya Perkhidmatan Pendidikan, the court held that the law must also be fair, justice, and non-arbitrary. Furthermore, in Lee Kuan Poh and Public Prosecutor, fundamental liberties must be interpreted generously. Therefore, any arbitrary application of a statute invalidates the arrest from the outset. The next principle is the doctrine of colorable exercise of power. This doctrine prevents the executive from doing indirectly what it cannot do directly. Even where a statutory power appears valid on its face, the court will examine its true purpose. In Pengarah Tanah dan Galian and Seri Lempah Enterprise, the Federal Court affirmed that the executive discretion must be exercised within legal limits and for the purpose intended by Parliament. If a power is exercised for political survival or to suppress dissent, it amounts to fraud on power and cannot justify deprivation of liberty under Article 5, Clause 1. The arrest also interferes with the constitutional right to freedom of speech under Article 10, Clause 1, Clause A. In Sibarasa Rahsia and Badan Peguam Malaysia, the Federal Court recognised that Article 5 and Article 10 are interconnected. If the speech being punished is constitutionally protected, the resulting arrest cannot be regarded as lawful. Although restrictions may be imposed under Article 10, Clause 2A, they must satisfy the proportionality test established in Azmi Sharom and Public Prosecutor. The restriction must pursue a legitimate objective, be the least restrictive measure available, and maintain a fair balance between public interest and individual rights. Applying these principles to the present facts, the arrest cannot be justified. First, the NSC declaration was ultra-vires and therefore incapable of providing a lawful basis for detention. Second, the state's reliance on the Sedition Act also fails. Gagah and Gigih merely made honest and fact-based criticisms intended to correct governmental defects. Section 3, subsection 2, paragraph B of the Sedition Act expressly protects such speech. As a result, the essential element of the seditious tendency is absent. The evidence further shows selective prosecution and mala fide conduct, where state powers were used to silence political dissent. Such conduct constitutes a colorable exercise of power and renders the arrest void ab initio. Therefore, because the NSC declaration was ultra-vires and the Sedition Act was deployed mala fide against protected speech, the executive failed to satisfy both the procedural and substantive requirements for Article 5, Clause 1. Accordingly, the arrest and detention of Gagah and Gigih were arbitrary, unconstitutional, and void ab initio. Moving to the issue of 3.2, Article 5, Clause 3 requires that an arrested person be informed of the grounds of arrest as soon as may be. In Abdurrahman and Tan Joko, the court clarified that the authorities must communicate the precise and specific grounds of arrest at the earliest possible opportunity. This requirement is fundamental because a detainee cannot effectively challenge detention or seek legal representation without knowing the basis of the arrest. Article 5, Clause 2 provides the remedy for habeas corpus. In Mahmad bin Daud and Government of Malaysia, the court described the judiciary as the ultimate guardian of liberty and placed the burden on the state to prove that legality of the detention. Similarly, Muhammad Ezam and Ketua Polis Negara confirmed that procedural non-compliance immediately renders the detention unlawful. Here, the authorities failed to specify whether Gagah and Gigih were arrested under the NSC Act or the Sedition Act. This shifting legal basis created procedural ambiguity and left them in a legal vacuum. Since the NSC declaration itself was ultra-vires, there was no valid legal foundation for detention under the Act. In conclusion, the authorities violated Article 5, Clause 3 by failing to provide clear and timely grounds of arrest. These procedural defects seriously prejudiced the detainee's constitutional rights and rendered the detention unlawful. Therefore, under Article 5, Clause 2, the High Court should issue a writ of habeas corpus and order the immediate release of Gagah and Gigih. Thank you.
Moving on to issue 4, where we examine whether the criminal prosecution initiated against Gagah and Gigih under the Sedition Act 1948 for criticising Guru's alleged corrupt conduct is sustainable. And we must analyse this in light of the Section 3, Subsection 2, a statutory exception for legitimate criticism. Furthermore, we will address whether this prosecution, coupled with the complete failure to prosecute Guru, amounts to unequal treatment, thereby violating Article 8, Clause 1 of the Federal Constitution and undermining the fundamental principle of rule of law. Issue 4.1 is regarding whether the criminal prosecution initiated against Gagah and Gigih under Sedition Act 1948 is sustainable, or if their statement fall under the statutory exception of honest, constructive feedback and criticism against the government with a view to remedying errors. To understand this, we look at Section 3, Subsection 1A of the Sedition Act, which defines a seditious tendency as one that brings hatred, contempt or disaffection against the government. However, Section 3, Subsection 2 explicitly protects honest, constructive feedback aimed at national betterment and criticisms aimed at remedying government errors. This distinction was clearly illuminated in the landmark case of PP and Oi Kisai, decided in 1971, where Raja Azlan Shah J distinguished lawful criticism from sedition, holding that criticism seeking reform or change in government policy is legally protected. The court emphasized that the speech must be assessed as a whole and only crosses the line if it objectively tends to stir hatred, contempt or disaffection. So we apply these principles to Gagah and Gigih. For Gagah, his communication was a private advice to Guru against corruption and cronyism. It was confidential, personal and involved absolutely no public statement or incitement. His sole purpose was to correct wrongdoing and promote good governance. Therefore, his conduct perfectly mirrors Section 3, Subsection 2 of the exception. For Gigih, His social media post explicitly stated that Gaga was providing honest, constructive feedback for betterment of the nation. The post was explanatory and objective rather than inflammatory. Furthermore, the rally he organized was to support an individual facing prosecution, not to incite hostility against the government. Thus, Gigi's conduct also falls squarely within the protection of Section 3, Subsection 2. Ultimately, their statement did not stir hatred, contempt, or disaffection. Applying PP and Oiki said, disaffection requires proof of disloyalty, enmity, or hostility, none of which are present here. The actions of Gaga and Gigi were aimed solely at remedying the alleged government wrongdoing, which amounts to lawful criticism. Consequently, we conclude that because Gaga and Gigi statements fall within Section 3, Subsection 2, their statement constitute a constructive criticism with a remedial purpose, so the sedition charges against them are entirely unsustainable. Now, we move on to issue 4.2, which is whether the prosecution amounts to a violation of Article 8 Clause 1, equal protection under the law and undermining the rule of law. Article 8 Clause 1 of the Federal Constitution guarantees that all persons are equal before the law and entitled to equal protection. This provision heavily embodies the principle of the rule of law, meaning all persons, regardless of status, are subject to the same legal standards. In PP and Tengku Mahmud Iskandar, the court made it clear that every citizen is equally responsible under the law, and an official or sexual status does not place a person above legal treatment. Therefore, a public office cannot justify immunity from legal accountability. Also, in Datuk Haji Harun bin Haji Idris MPP, the prohibition against unequal treatment extends directly to prosecutorial decision. Public authorities must exercise their power consistently with constitutional equality. In the present case, Guru, the Prime Minister and alleged perpetrator of corruption, was completely uninvestigated and unprosecuted. Meanwhile, Gaga and Gay, who merely criticized this alleged conduct, were swiftly arrested and charged with sedition. This stark differential treatment raises severe concern of selective and discriminatory prosecution. To conclude on this point, while the public prosecutor possesses discretion to initiate criminal proceedings under the Constitution, this discretion must be exercised consistently with equity and the rule of law. It cannot be exercised arbitrarily to shoot powerful actors while punishing whistleblowers. As stated in the case of PP and Su Liang Yu, the dominant idea behind the Article 8 Clause 1 is equal justice. Equality before the law requires a fair and consistent legal approach, and unequal enforcement directly undermines these constitutional guarantees. Because Kuru was subjected to no legal action despite Kuru allegations of corruption, while Gaga and Gigi were heavily prosecuted for exposing it, this selective treatment fails the test of constitutional consistency. Therefore, the prosecution constitutes a clear violation of Article 8 Clause 1 of the Federal Constitution and must be struck down. That's all from our group. Thank you.